Thanks very much, Ceann Comhairle, and I have to say I feel like I'm kind of out of sync with everybody else in relation to this, because while I'm obviously very glad that the bill is before us today, there's no doubt about it, it's incredibly long awaited. The biggest problem I would have with it is that there are two key areas that this legislation was specifically teed up to address, and as far as I can see, on both scores it's deficient and will need radical overhaul if this bill is to achieve what I think all of us hoped that it might achieve. And the two particular areas really are in relation to periodic payment orders, which other deputies have addressed, and particularly the whole issue of open disclosures. And I honestly believe that in the manner in which both are dealt with in the bill, and the way in which they've made it into the bill, if you like, in the final stage, that they nearly end up thwarting the very objective that's there in the first place. Now, regarding the open disclosures provision, I think there are two problems with it. The first is that in the current form, the bill essentially provides that any open disclosure made and any information gathered as a result of the open disclosure process cannot be relied upon as evidence in any subsequent civil actions. Now, as far as I'm concerned, this absolutely conflicts with long-established principles of national justice and is likely to actually adversely impact on the trust between the patient and the health service, the very objective that the bill is designed to enhance. And in other jurisdictions like the UK, for example, no such restriction is placed on this information. And the other key problem with open disclosure is that here in our legislation it's voluntary, it's not statutory, and that's a massive failing as far as I'm concerned. But in terms of the periodic payment orders, obviously that's long awaited. Other deputies who spoke before me have addressed that. I think the bill could have represented an excellent opportunity to address the deficiencies in the existing lump sum model for compensation by replacing periodic payment orders. But in order for such a system to work, then the periodic payments have to be linked to the right index. Won't work otherwise. And to ensure that annual payments remain as close as possible pegged to the future costs of medical care and treatment. That's what we should be striving to get to. And the original recommendation unanimously endorsed by the Judicial Working Group on Medical Negligence was that an earnings and cost related index would be introduced. But the bill before us, I suppose for budgetary reasons, I don't know, has actually gone for a completely different model and recommends a harmonised index of consumer prices as published by the CSO, which is, as I say, the opposite of what the Judicial Working Group recommended, and completely ignores their unanimous recommendation, because linking payments to the CPI actually ignores the difference between the general increase in consumer prices compared to the much greater increase in medical wage and treatment costs. So therefore, if you like, as it currently stands in the bill, there's a very real danger that the government are putting people who have been catastrophically injured in our health service at risk of running out of the money they need to live and maintain an adequate quality of life. Now, granted, I know, and the Minister undoubtedly will say, but sure, look, there's a review in it. We've a review built in to say that the operation of the index in every 5 years. But I have to say that's a bit half-baked, really. It's like saying, well, look, it's the worst of all worlds. We kind of know it's limited, and sure, we'll throw something in there. And I don't think it's adequate, and this absolutely has to be addressed when the bill goes to a later stage. And I have to say I compliment the work done by the Medical Injuries Alliance in their address to the Health Committee on these issues. In terms of the points about open disclosure, I would like to develop them a little bit, because I think in the bill in its present form they're totally inadequate and actually contrary to the principles of natural justice. And again, because the bill says that any disclosure and associated information provided as part of the open disclosure in accordance with the legislation is not admissible as evidence in any court proceedings in connection with any injury or death caused by the health service provider. Now, this is an absolute missed opportunity as far as I'm concerned. I think the system we have presently is clearly not working. All of the deputies have articulated that position. People who are injured by our health service are presently forced into litigation to find out what happened, firstly, and then to try and get justice. And yet we've had a national open disclosure policy since 2013, and the policy hasn't changed the fact that expensive and antagonistic litigation is the only way ordinary citizens have to get anywhere near the truth. And I think that's a fact. I think it's interesting that back in February 2015, when the then Minister for Health, Leo Varadkar, described doctors who failing to be fully open about incidents as the medical equivalent of a hit and run. I think he's actually right about that, but he said at that time that if more doctors were open about making mistakes, then there would be fewer lawsuits. And that's true. I think that's been verified in other jurisdictions. But he promised to make it mandatory for medical and nursing staff to admit errors that have caused harm to patients. That promise isn't delivered in the legislation that's before us now. And you'd have to beg the question, is it more about protecting the system when people make open disclosures rather than giving patients and families the right to full and open disclosure? And I think preventing evidence gathered through open disclosure being used in subsequent court cases, frankly, Minister, is ludicrous. And I actually think it would be constitutionally suspect. I think the Medical Injuries Alliance have made good points in regard to this. They say it would be abhorrent to the administration of justice that a court might be precluded from considering all existing information necessary to establish relevant facts before making a decision on questions of liability. There's less difficulty with the proposition in the bill that admissions made pursuant to the legislation cannot be deemed to be an admission of liability. That's absolutely fair enough. But however, when there's a dispute on liability, it's absolutely essential that the court has the right to consider all relevant factual information gathered on foot of the legislation, and that has to include any open disclosure and all records created for the purpose of making that disclosure. Because, let's be clear about this. Patients are at a massive disadvantage compared to the health service provider in terms of knowledge when it comes to establishing how an adverse incident came about. It's the service provider who's in control of the information, let's be clear, and sadly with this legislation, unless we change it at committee stage, that won't change. Patients might get some more information, but they won't be able to do anything with that information, which as far as I'm concerned is totally wrong and actually makes the legislation somewhat redundant. Allowing information and records given over as part of an open disclosure process to be entered into as evidence in court proceedings doesn't mean that the court proceedings are going to succeed, and that's fair enough, absolutely. The legal safeguards are still there because, the patient would still be required to establish liability when there wasn't an admission of the same, and that, as far as I'm concerned, would provide ample protection for the service provider, particularly when you consider that the burden of proof which the patient has to reach in any civil action is actually a very high one, because it has to be proven that the doctor has been guilty of a failing which no other reasonable doctor of like skill or experience would be guilty of. So I think it's important that we need to examine the legislation that exists in other jurisdictions, and a statutory duty of candour exists in the UK since 2014. Now, following an adverse incident there, health service organisations have to give a patient a full explanation of what is known at the time, including what further inquiries will be carried out, Organisations must provide an apology. They must keep a written record of the notification to the patient, and on top of that there is a statutory duty to provide reasonable support for the patient, like, for example, maybe an interpreter to ensure that the discussions are actually understood by the patient or their families, giving emotional support and so on. And in the UK's guidance note on implementing the duty of candour, they actually say a public authority's objective must not be to win the litigation at all costs, but to assist the court in reaching the correct result and thereby to improve standards in public administration. And that, as far as I'm concerned, is what we should be trying to achieve by this legislation. The UK's statutory duty of candour came about as a result of the Francis report, which investigated catastrophic failings of the NHS in Staffordshire. Now, let's be clear about it. We're devastatingly familiar with catastrophic failures here in Ireland. Think Portlaoise, think Portiuncula. The HICWA report into the deaths of babies in Portlaoise was hailed at the time by Minister Varadkar as a watershed in terms of maternity services in Ireland, but it was published years after some of the incidents actually occurred. The report made sweeping criticism of the HSE and its staff for repeated failures in the care in the units and the failure, critically, to learn from those mistakes over years. And who's to say, had they learned from those mistakes, that some of the tragedies would not have occurred? And a statutory duty of candour would actually be one of the ways to address this. But despite having Portlaoise in our recent history, the government has shied away from this in this legislation. I can't understand that. Let's look back. The HSE Director General, Tony O'Brien, at the time threatened to injunct HICWA when he saw its first draft report on Portlaoise and its criticisms of senior management. Bear in mind that all of this happened while the HSE had at the same time had a voluntary open disclosure policy, the kind of similar one to what we're debating here tonight. That hasn't done a lot of good for the families in Portlaoise who spent 10 years trying to highlight what went on at the hospital. And therefore, I have to say, I found it a bit bizarre, to be honest, that in the Minister's briefing note on this bill we find the following quote: "There is no question that the protections in Section 10 provide a hiding place for incompetent, negligent or other unprofessional patient care. Organisations and health professionals continue to have accountability mechanisms." To be honest with you, having spent a lot of time working with families and the campaign to ensure mandatory inquests in cases of maternal deaths, I can certainly tell you that accountability mechanisms that are there now are absolutely not fit for purpose. They clearly just aren't. There were 8 inquests into maternal deaths in Ireland between 2007 and 2015. All of them had to be fought for tooth and nail by the families involved in the face of intense HSE stonewalling, and all 8 were marked by consistent under or non-cooperation by the hospitals involved. Families need to know when tragedies happen, and tragedies will happen, sadly. It's not necessarily under anybody's fault, that's life, but we need to be open when they do. Our hospitals are chronically understaffed and underfunded, which means that accidents are actually probably guaranteed. But, the full scale of the crisis has to be known by the public, and I think a statutory duty of candour is the key way of providing an impetus for change. There is a huge issue here, I think, also, in that this proposal really to prevent a patient from being able to rely in any way on the open disclosure process is actually likely to breed a lot more distrust. I mean, if you think about it, right, a patient involved, if, for example, a patient is provided with clear and frank information about how an adverse incident happened, but then later in court the very same facts and version of events are denied by the service provider, What's that going to do about public confidence in our health service? It just isn't. The reality is the bill as it's presently structured will lead to increased legal costs. Now, we know the state already spends tens of millions in fighting damages claims, as incidentally do the families who have to put up with the money in fighting for that as well. But I mean, if one party to a civil case has access to relevant factual information and the other party is denied access to the same information, then the only consequence is going to be much more hard-fought, lengthy and costly civil actions, because patients then are going to be forced into a situation of instructing a bunch of independent medical experts to give expert evidence needed to establish substandard care or causation, something which had already potentially been established under the open disclosure process, but that they couldn't use in court. I mean, that's bizarre, and that is absolutely needed, is going to need to be changed. I think on the other side of it, if the open disclosure is legislated for properly, not only will it lead to an improvement in the level of trust which patients have in our health service, which is supposed to be one of the objectives, but I genuinely believe, as Minister Varadkar said 2 years ago, that it would lead to actually fewer civil actions, less trauma for injured patients and family, and less money wasted on litigation, but not as the bill is there now. And I think in some ways actually the Department of Health agrees, because the report of the Commission on Patient Safety and Quality Assurance, published almost a decade ago in 2008, had this to say: over the last 2 decades there has been a growing support in the international literature for the concept that doctors should make full disclosure of medical errors to their patients, as well as enhancing patient safety by the acknowledgement that an error occurred. It is also in keeping with the ethical commitment of honesty to patients. Failure to communicate effectively with patients following errors therefore damages the integrity of the profession. Studies show that openness can decrease the trauma felt by patients following an adverse incident, and that patients often forgive the medical error when it is disclosed promptly, fully and compassionately, and action is taken to make sure that it doesn't happen again. And that's, if you like, the battle that the spouses and partners of the women who lost their lives in maternal deaths in our hospitals over the last number of years have been engaged in when they've launched their campaign to secure mandatory inquests in cases of maternal deaths. It can't bring their wives back, but it can stop it happening to somebody else, and that has to be the objective of this litigation. Sadly, I met in my office last week again an incredible man, Micheál Greeley, 84 years of age, whose wife Kathy went into hospital on Christmas Day 1972 to have their first baby. The baby died. It was born on Christmas Day because the COOM didn't realise that the rhesus negative in the mother and the rhesus positive in the baby, and that wasn't corrected. Even worse than that, Kathy herself was given an anaesthetic when she should have been given an epidural. She vomited Mendelssohn's syndrome and died 7 weeks later in 1972. Her husband, at 84 years of age, is still carrying on the fight to find out what happened in that case. He's seen documents which have said that his wife's death was avoidable, but he's had no explanation for why it happened. The names of medical personnel involved in that case, the anaesthetist in particular, was withheld from him over decades. Then he found out the correct name. After that, medical personnel involved in his wife's care gave him information which led him to believe that the anaesthetist had a drug problem and probably shouldn't have been working on that tragic day, and yet he hasn't had any proper answers. These are things that follow people for a lifetime, and the damage and the trauma that they cause, as far as I'm concerned, is absolutely reprehensible. We've nothing to fear from a proper duty of candour that can actually protect doctors and nurses as well in terms of the personal liability for accidents. In the final Francis report, which led to the UK's statutory duty of candour, Robert Francis QC very reasonably makes the point in regard to professional misconduct proceedings that professional regulators would be far more lenient on those who owned up to their errors with a serious effect on patient safety than they would with those who denied it or sought to cover up their lapses. He said, "We need a situation where the legal advice is going to be, I know this is unfortunate, but you are going to be better off by telling them about it, by being open and honest." And sadly, the bill as it's currently structured does not do that, and we owe it to people who will fall foul or be the victims of adverse incidents in our health services to have a proper bill. So I really hope we can work together at committee stage to ensure that this bill does deliver on open disclosures and periodic payment orders in the way in which I think all of us believe citizens should be treated.
Thank you, Deputy.